Okay, let's resume the meeting. Under Secretary, can you respond to Dr. Hon Wang? Well, we have plenty of time now. I think Dr. Wang hoped that we want to expand the coverage so that the volunteers and the trainees will be covered. So we noted this comments, want to listen to more views, and we have an open mind to this. For the sexual harassment from involving students from different academic institutions, will that be amended in this round? And the government claims that the EOC suggestions did not include this. I noticed that. However, the EOC recently just released a survey on the sexual harassment in tertiary institutions, which shows that it happened between or at joint universities functions. So that's the latest survey findings from the EOC. If the government claim you just throw the ball back at the EOC, and I told you EOC just released a survey pointing out to this problem. So if feasible, in this round of review on sexual harassment, they should include sexual harassment from students at different institutions to be included. As for harassment took place that is not at the workplace or outside of schools or at park or MTR or public venues, if the government want to save that for another round of review, I would find it acceptable. But if the EOC had already released a report pointing out that the sexual harassment at the inter-university level, I suppose you should include that at this round. For the rest, you can save for the next round. Can we do this? Under SEC, understood. Whenever there's a survey finding or a questionnaire come out that would attract the public concern, looking at the legislation, since the sexual harassment under the existing legislation have a clear undesignated prescribed area and for the inter-universities and didn't include the staff at inter-universities, that would give rise to different problems. That's the first issue. When handling this bill, we heard from different members that other organizations, for example, charities and churches, have not been put under scope. Well, is it better if we do it, consider it on a systematic manner, which is the more preferred way of addressing this? And this issue is sort of relevant to the harassment of breastfeeding. So without a specific relationship, how should we deal with this? Which is similar to sexual harassment, because some of them circumstances may be difficult to pinpoint. So the Me Too movement have generated a huge debate, which bring out some questions which require us to take a second look. So for these two related topics, we should do a more in-depth investigation. So because we're not in too much hurry. And next, Mr. Ray Chan. I want to follow up on at the last meeting that within the same premises, and there are a lot of different relationships this bill able to protect them. On the March 21st meeting, to answer half of my question, that the new bill would applies to different workplace participants, and for example, the two personal assistant of different members working at electrical complex, and the victim harassment shall benefit from the new provisions. And also at the last meeting, let's say me and my complainants, would they constitute a or whether my staff and the complainant would constitute a relationship. Let's say within electrical complex. Let's say, Chairman, like your staff and my complainant, that would not fall into the employment relationship as per the principal, commission, agent, principal, and partner in the firm. So in which the complainant could only have a relationship with the unit they belong and covered by the provision. So for the same premises, if a different class of service beneficiary, so and for the service provider and the service recipient would deal with that without this workplace participant issue. Well, for the SDO, let's say an air hostess providing services in which a guest is in a seat. If the passenger harassing the air attendant, there will be breach of law, and vice versa. So under a specific relationship, the service provider and the recipient will have a natural relationship, which is separate from the workplace participant concept. Let's say in my office, there's someone to make a complaint, and my staff will be the service provider, and the complainant will be a service recipient. However, within the same building, they will meet, let's say, a staff from the chairperson's office, and the complainant has not had a service supply and receiving relationship with your staff. So can I apply the workplace participant concept? And you claim it's not necessary, that the new provisions need not to be invoked. Let's say your staff or my staff and harassing and complaining can be dealt with existing legislation. Under Secretary, well, simply put, they will not be covered because the concept of the common workplace that aims to deal with which the harasser and the harassed have not have a direct subordinate relationship. However, not all persons enter the common workplace will be covered. Though, as per AOC's suggestion, we were using successful overseas proceedings that have been well tested, of which there are 7 roles of employer, employee, contract worker, and the principal, followed by commission agent and principal, and the 7th, partner in a firm. There is no such identity or role as a service provider, which is this where this concept doesn't cover. So that we heard that whether we can include volunteers and trainees, that will be 7+2. So that's what the discussion about. Chairperson, so do you understand? Let's say my staff harassing your complainant, so that would not be covered by under existing and new legislation. Yes. As for the high-speed rail, the area and under wind jurisdiction, and the February 22nd, we see the response there. So is it only the civil matters under the reserve matter under the XRL cooperation agreement? Let's say that where the criminal liability involved or where there are vilification is involved, that we have to only be prosecuted under the laws of that jurisdiction. For the civil and commercial dispute are under reserve matters, and criminal is not. Next, Mr. Hsu Ka-chun, followed by Elizabeth Quiet. So my question is on the definition of workplace participants. In the administration response, and the 5th part, that whether it applied to unpaid my trainees and volunteers, it just depends that whether they are employee, but not solely due to that whether that they were prepaid. Thanks to Undersecretary for explaining the help open mind on volunteers. I teach social work in universities, and I, I'm just expired my term of the social worker registration board. So I know a bit about the social worker trainees, and currently they're in a gray area. Since for social worker interns, whether satisfy the definition of the employee.
I think the trainee must go through the internship before they can graduate, and universities will arrange them to specific homes to undergo training. So they don't sign any contract with the NGO. They're not paid, but during the trainee internship, I think the work that they perform was similar to those social workers working at the premises. So will these trainees satisfy the definition of employee and therefore be entitled to protection? And secondly, to follow up on Ray Chen's follow-up question, that is, in the same workplace, let's say in the premises of the same NGO, you have social work trainees from two institutions, there, and if there is an incident of sexual harassment, will they be protected under this bill? Thank you. To answer your first question, the social work trainees who are not covered by a contract, if there is no contract, then according to the definition under the discrimination laws, then they will not be considered to be an employee. The most important thing is whether or not there is a contract. So in this case, they will not benefit, vis-a-vis the employer-employee relationship. But we're here to listen to members regarding how we should deal with the question of the status of trainees. For trainees working in the same workplace, and if there is sexual harassment, how do we deal with that? Well, that would depend. I think if we were to amend the ordinance in future, then they would be covered. Otherwise, they would not. But it would also depend on their relationship with the organization. Even if there's no contract, the principal is there. The principal would be the NGO. And the principal can instruct him or her to do the work required. So whether or not the court will consider the relationship between the trainee and the principal and be considered as an agent. In that case, you could argue that the trainee should also be protected. So it depends on, if we were to amend the law to explicitly protect the trainees, then I don't think then we can dispense with such discussion or arguments. Well, social work education has a history of several decades. The social work department has just celebrated the 70th anniversary. Dr. Wong said that since we're going to amend this law, we don't want to leave out anything. And every year we have almost 1,000 social work students going on, on internship, whether they are studying the year 2 or year 3. About 1,000 of them will go to go through internship. So we don't address this problem. Of course, the Undersecretary said that he has an open mind on this, but if we don't address this question, then the problem will persist. And will still remain unresolved for 8 to 10 years. Dr. Elizabeth Kwok, and I'll read out the names of the other members: Poon Siu Ping, Chang Chung Tai, Holden Chow, and thank you. The government has already taken into consideration our suggestions and expanded the scope of the bill, and protection is now afforded to, not only women who are breastfeeding their own children. So just now we were talking about women who are actually regarding, the harassment or vilification of women who are breastfeeding or expressing milk. Now, indeed, we do have women who are subject to harassment, and such harassment may not be directly considered to be sexual harassment, and therefore such harassment, they will not get the protection under the current ordinance. Of course, the government said that we should, come up with a more comprehensive ordinance. We are now discussing the STO. That has gone through a long, very detailed discussion. For example, we even now we cannot include under the STO offenses of people illegally taking pictures of the private parts of women. You now promise that you will. You promise that you will propose a new legislation. We don't know how long that would take. So the intention of the bill is to protect breastfeeding women from harassment or discrimination, because the current laws do not protect them from being, harassment or vilification. So apparently there are some gaps in this bill. So I'd like to ask the government to look further into this and explain how you can really offer genuine protection for women so that they won't be subject to discrimination or be offended. So is it out of scope if we were to include that into the bill? I would also like to ask our own legal advisor as to whether or not this is out of scope. I'll ask the Secretary to respond first. Regarding harassment on the basis of breastfeeding, members would like us to also cover that in the bill. Policy-wise, this is what we want to do. It's exactly because we want to do a thorough job that we are now suggesting that we should not, hastily enact legislation to address this issue by way of the bill. And also, it is not compatible with the requirement under the rules of procedure. We hope that together with we will further explore that together with the subject of sexual harassment, and then come up with a more comprehensive solution. As to whether or not the amendment is out of scope, that would be for the President of this Council to decide. In considering whether an amendment is beyond the scope of the bill, we will need to consider the long title, the details of provisions of the bill. Normally, if the amendment does not amend the title of the bill, it only increases and adds certain details, and it would not be out of scope, and amendments can certainly be moved. Since I don't have the provision with me at the moment, I cannot give a definitive answer, but basically that is the principle. I don't think that we can have a perfect piece of ordinance. But I think it is better to have some protection rather than having no protection at all. So I hope the Undersecretary, the Undersecretary will consider that. Dr. Pun, I'd like to welcome the government who now said that they have an open mind regarding the question of trainees and volunteers. There are two types of volunteers: those who are organized, and those who are freelance or volunteers who are not organized. We agree that there should be more protection, and you said you are willing to explore into that further. But have you considered the definition of volunteers in other jurisdictions, and how do they define, volunteers? Could you give us such information? Now, so are there any definition or standards that we can make reference of? Last time, we also discussed this question of workplace participant. We all know that the situation is very clear for those who are covered by contracts. Previously, we also expressed our concern regarding workers, employees of contractors for work outsourced by the government. For the 7 categories of workers, do you also include this category? Well, those 7 categories do not include volunteers and interns. Therefore, in our discussion today, we'd like to hear your members' views as to whether or not we should cover them. The question now is whether or not we can easily address the question of the definition of volunteers. I understand in Australia, they just take a common sense approach. There is no definition of volunteers. If we want to address this by way of law, then we have to look further into the practices in other jurisdictions and also the practice of local organizations which organizes volunteers. We certainly would need to consider that. Regarding the freelance workers and the self-employed workers, are they also covered? So if they are self-employed, if they say, for example, they go to a bar, they are employed by the bar, they only there to to perform, then he would be considered an employee, and like the other employees and contractors, they would be protected in that particular workplace. Dr. Chen Chung Tai. Thank you. I've not really, raised any question regarding the subject of workplace. Today, regarding the definition of workplace, you said that you would include, unpaid trainees or volunteers. I would like to ask some question regarding certain specific situations. For example, in swimming clubs, where the swimming coach and the learner, I think the relationship is not like that of employee or principal or volunteers or trainees. I think the example you provide has not really covered that scenario. Could you give us a more detailed explanation? Let's say for swimming clubs or athletic clubs, what is the relationship between the coach and the trainee? How would you define such a relationship? Thank you. Again, this takes us back to the fundamental question. If there is an established relationship, then we don't need to address that by way of the workplace. Regarding relationship between the trainee and the coach, the question is whether or not the trainee pays the instructor, or whether the instructor could be employed by an organization. He's just an employee, governed by a contract. If there is such a relationship, you already have this relationship, then you don't need to address that by way of a shared workplace, except that so as for the coach or instructor, it would depend on whether or not there is such a relationship. I think, what about the church for clerical workers? So there's no employer-employee relationship, right? I think this is something that deserves to be explored. The current ordinance does not, cover matters relating to the church. So I understand that the proposed amendment is a result of certain social phenomena, and that's why we need to follow up that by way of law. Take, say, for example, the Me Too movement. I think that is a very sensitive subject. People have different views about that. But regarding clerical workers or clergymen and so on, there have been many incidents which involve sexual harassment and so on. So, but in the bill, regarding special relationship, can we say that it is out of scope? Obviously, the 7 roles under the common workplace together with volunteers and interns, it would not address the question of church workers. And that's why we propose that we should review the subject of sexual harassment, because we do have a problem, you know. Chairman, I'm not deliberately trying to to make any express an opinion regarding the clerical or church workers, but Mr. Siu is concerned about the social work interns. But for clerical workers, they are involved in certain spiritual exchanges with believers, and it may, for example, you may have female members of the congregation who may not welcome the counseling or spiritual comfort by clergymen. These things happen all the time.
Why not include this in this current round of amendments? We understand Dr. Chang's concern, so we need to seriously examine the existing provisions on sexual harassment. First, you mentioned education, then other domains. So, for example, service provision, and clubhouse. And well, the definition of clubhouse on not more than 30 people that we formed for legitimate purposes of education, and sports and so on. Can you interpret church as some kind of club? So that be subject to deliberations. However, we never expressly state as churches unlike schools. Currently, the SU is quite clear that we include the schools for clubhouse. So can we, while people have different opinions to whether churches are regarded as clubhouses, and the Undersecretary claimed that they will need to be thoroughly examined. So next, Mr. Hon Chiao, followed by Ted Hui. First, I welcome this miscellaneous amendment bill, and for example, Dr. Elizabeth Quat on the further protection on breastfeeding, which we hope to be achieved by this bill. Besides doing this in this bill, I want to issue a strong view. The Bureau is aware that earlier on LegCo, I have submitted a written question, which I got a reply from CMAB. Even though this time round, this question will not be addressed. How is it important? However, the RDO, the serious vilification itself, is of a criminal nature. It's a criminal offense. From my observation and press report in the past, there has not been any criminal prosecution ever taking place. And through my written question, I confirmed my observation for the past. The RDO on there have been no successful prosecution on racial serious vilification. However, we can see that we have a lot of different incidents in which some of the EMs are confronted or being hurled as an abuse or seriously vilified. However, in the past, there has not been any criminal prosecution. We have no idea of the cases and the standards. Thus, this public may be interested. So I would like to listen from the Bureau, and they take the opportunity to take your position on this. So how you deal with future enforcement, and since it's quite widespread in the public, how you deal with the enforcement, or the laws itself the threshold may be set too high, thus not able to initiate any prosecutions. So I want to listen to the Undersecretary for the CMAB's position. For the views raised by Mr. Hon Chiao, that currently under the RDO, the vilification as illegal, so that for vilification you're inciting people to incite hatred towards it, but or severe mocking on grounds of the different race, and for serious vilification endangering the person's safety and the asset. The former is civil while the latter is criminal. Well, concede that there will not have any prosecutions against serious vilification. That will keep in dialogue with the EOC. Is that no incident occurred? It's just people are not aware that you can invoke this relevant provisions. So we will keep close communication. And even for vilification for the civil side, we hope to let's see if we're able to get more data. Since while civil cases between two private citizens, whereas the government is not involved, we will not have any data. So we have to see the only way to collect such data. The law is in place, but whether we can use it well, that will follow up. I hope you can review the criminal prosecution on the threshold to initiate or the enforcement situation. For the civil, in your written response, you claim that the civil matter, the suit is between two private citizens, that you not interfere. However, will you communicate with the judiciary, since the categories of the crimes, maybe the judiciary must be knowledgeable. So I wonder, have you had to any statistic compilation? This is similar compilation. I think these are all publicly available information. However, there's no mechanism to notify Department of cases of vilification. So we'll work with the EOC, since they are the one promoting this. Is there any way that we can grasp this picture quicker? Ted Hui, followed by Eunice Young. Apologize for being late. Since I attended the court hearing, I hope that I'm not repeating other members' questions. So on the harassment on breastfeeding, so when the public, there was strong calls asking for amendment. We've surveyed 150 people, and over 60% claimed that condoning this behavior will prevent the adoption of breastfeeding. About 70% or 67 respondents agree that we should legislate to deter the harassment. Well, the government's position has been that this time it seems to be rushed, not feasible. So why is not feasible? Since in the other discrimination ordinance, they have a clear definition on harassment, for example, unwelcome acts or on the designated premises where you have backtracked it, but you claim the term been too broad, so that it was aligned with other DOs. For example, employer, employee, education institutions. You simply just duplicating from other discrimination ordinance. So why is it not feasible? When you claim it's too rushed, it's not feasible. Well, you even invoke the ROP. I never see that the chairperson will veto the administration amendment as out of scope. Even if we don't amend the long title, if we change the provisions, the act of harassment in other discrimination ordinance or in overseas provisions, well, that all discrimination ordinance would deal with harassment. You just need to amend the provision instead of the long title. So let me sum up. It's just unwilling to do it instead of not able to do it. As one you speak more specific terms in legal language, why it's not feasible? Ms. Hui, the legal advisor is checking. The government want to move amendments, and yet it would deem the chairman's out of scope. Well, the legal advisor would try to find out which bill it is. Well, the bill was finally withdrawn by the government. Thank you, Mr. Hui, for joining our discussion. Before you enter the room, I already explained using legal language that why technically amending in part the harassment of breastfeeding is not feasible. Before I explain, before you come in, I said that I will agree with members that want to deal with this kind of harassment. And what we're advocating is that we want to address it at the roots instead of just in a piecemeal and partially. Since the question raised by members, including the cases raised by yourself, involved at a park or a restaurant, chairperson, he's out of scope. I'm not talking about the stuff. I'm talking about the designated premises. So why is it not possible under the designated premise? So for the RDO deal with two questions. One will discrimination, the other one harassment. So the harassment and discrimination are two different matters, and yet they're in the same ordinance. Discrimination will be a differential treatment or treating people badly, simply put. And for harassment, sexual harassment. Well, the harassment in the discrimination ordinance is basically sexual in nature. So which is to commit acts, unwelcome acts of a sexual nature. Now that we have this amendment to this bill, the bill was submitted, we have set out the scope by the long title or from the electrical brief that for the SGO only deal with two questions. First, we introduce a new concept called discrimination on the grounds of breastfeeding. So discrimination but not harassment. We can't include harassment. Second, we deal with other amendments with sexual harassment and racial discrimination. So mainly these two questions. So what? So there's no connection to the harassment of breastfeeding. So this kind of harassment is not sexual harassment. Otherwise, it could have been dealt with by existing legislation. What we're dealing with is that offensive and harassment. Thus, this is a completely new category. Then it's not adding details to existing legislation. Though we are actually introduce a new concept that have been touched on in existing legislation. So clearly exceeded the scope test, thus it will not pass. Thus that's why it is legally unfeasible. 10 seconds. Yet under RDO and DDO and the relevant harassment provisions are already being covered. So it's all dealt with by EOC. You claim there's no sex discrimination. That's why I'm asking you to put it back in. And you claim this is new, thus it's not feasible. You haven't asked me why you can't put it back in. Well, you claim that is because it's not there. It's not logical. Eunice Young, I want to follow up on the harassment on breastfeeding. Well, the Undersecretary tried to explain two different concepts. We're looking at current statutes, and the administration proposal is seem to be a favor towards on a harassment at the workplace. Well, this my take is that harassment at the workplace, or two, the sexual harassment suffered by women in public places. I see that currently, I see their protection in the workplace if their employment or education or service provision. I see this is a workplace, and this provision, the bill does not cover women in a non-workplace and other public places. Mr. Ted Hui tried to explain some examples. Let's say in a taxi or in public place, you've been harassed by your gaze, by language and acts. So that we're asking that can we include other circumstances? My view is that this bill is biased, address the workplace but not other aspects. I know the administration has taken into account the views of the public and the members have expanded the scope. So on collecting evidence and the circumstances, can you further expand it so that a lot of women can benefit?
Under Secretary. Thank you, Ms. Yong. We are amending the ordinance. When we amend an ordinance, first of all, we have to define the scope, especially involve matters relating to human rights and discrimination. I think the common approach is that we first define the scope and the designated relationships so that we will not seek to cover all kinds of scenarios and all kinds of circumstances. I think there's a question of balance here. That is a balance between personal freedom and the freedom from being subject to discrimination. If you look at other jurisdictions, I think more or less the same model is adopted. That is, one would need to actually, strike the balance. For all the discrimination ordinances in Hong Kong, again, we apply the same, we adopt the same wisdom. That is, we will define the scope. We now have covered, employer-employee relationship. We cover scenarios including education, workplace, premises, and so on. The EOC has now reviewed all the discrimination laws, and they've now proposed more than 20 priority areas where they propose there should be amendments. And then we can step by step further expand the scope, and we've selected 8 scenarios or situations. But of course, these 8 areas may not cover all the areas members would like to seek improvement. You refer to the situation of passengers in a taxi. In a common workplace, for example, can we cover all kinds of relationship of people in a common workplace? Not necessarily. So, but then we can also cover the service recipients. It's not that we don't want to expand the scope as far as we can, but under the present, framework, when we amend the ordinance, we have to define the scope, and given that scope, we'll try to do the best job we can. We've heard, comments about definition of breastfeeding and definition of children and so on. So it's not within the same scope. We've not tried to expand the scope. On the subject of volunteers and interns, again, they fall within the same scope. But if we were to further expand to the subject of harassment on the basis of breastfeeding, it's an entirely new concept, and it's not in the bill itself. So technically, therefore, it cannot be done. But we're not giving up on that. We just want to do a more thorough job by way of a new piece of legislation. And we are not just looking at breastfeeding, discrimination on the basis of breastfeeding, but also sexual discrimination. Well, another question. In your reply dated the 21st of March, I understand that you've set a very high threshold. You would need to consider to decide whether there is any indirect, discrimination or harassment. I think the threshold is too high, and as a result, we will not be able to enforce the law regarding breastfeeding. Well, that is a case of direct discrimination. That if you do not allow the person to express milk, that is against the law. For indirect discrimination, you may say nobody is allowed to take a rest or going out to the premises to smoke. Then if everybody is not allowed to rest, including the pregnant women, the breastfeeding women. But imposing that requirement on the breastfeeding women will make it difficult for that mother to comply. Well, in your reply, you say the court will take all circumstances into consideration, and you've given the example of, you know, I think all these scenarios you covered will make it very difficult for you to enforce the law, because it's very difficult to define what is indirect discrimination. As a woman, if I provide all kinds of evidence, I may still not be able to prove that my employer is engaged in indirect discrimination. Well, for indirect discrimination, you don't need to prove the intent, so long as I can furnish some objective facts and the constraints or restraints that he imposed on me is considered unreasonable by any ordinary rational person. So the threshold is there. It's not that it cannot be enforced. It's now my turn. Under Secretary, you've heard many members touch on areas which you say is out of scope. Of course, when we enact any piece of legislation, we have to consider the legal principles. So I would like to say that if the government want to move an amendment which is considered out of scope, going beyond the scope of the bill, and the government is therefore advised not to move that amendment. I think this was exactly the case when the government proposed the stamp duty amendment bill. Well, the amendment the government wanted to propose was considered out of scope, but the government was able to move another amendment in time, and as a result, the bill was passed. Now, Under Secretary, many members are concerned about discrimination of women who are breastfeeding, and you said that you need time to study all the ordinances before you act. Like the stamp duty ordinance, eventually the government moved in a different amendment, and that was taken care of by the Bills Committee. So how much time do you need before you can move such an amendment? Of course, it would depend on whether your new amendment is out of scope, and if it were out of scope this time, would you do like what we did when we scrutinized the stamp duty ordinance? Would you be able to? Will you have enough time to move another amendment? And how long would you need? And if we are going to have, consider both amendments, would that be out of scope, or should we deal with this amendment first, and then you can work on the other amendment? I think, in my experience, I don't think you can make it. Would it take longer or not by working on one alone or working on both together? If the council want us to, to do this, and we would then ask, there are still 19 other proposals from the EOC, and members of this Bills Committee also, such as Dr. Wong, propose another amendment. So there are more than 20, areas. So if you have 19 plus all these other proposed amendments, you ask how long we will need, then we can certainly go back and study that. The question is, first of all, members will need to agree to these 8 amendments first, and meanwhile we can find out how long we will need before we can, move a new, bill to cover, discrimination on grounds of breastfeeding. I don't think we have to wait until we've done that before we scrutinize the bill. Of course, we would like to do it as soon as possible, and we're prepared to consider that. If the Bills Committee has a consensus, but these proposals are out of scope and you're not able to move an amendment, would you then consider moving a separate amendment? Otherwise, this is the third time that we are discussing these proposals. If after 3 rounds of discussion we already have some consensus among us, then while we are scrutinizing the bill, can you meanwhile also study all those other suggestions as well? I think the normal approach is that after the bill becomes law, we will come back to this council and do what we need to do and what we can do. But then you suggest that we should, wait until whether we can we have clarified whether we can also, move another amendment in replacement. Then we can certainly go back and consider that. Dr. Wong, I'd like to follow up on the question of I'd like to follow on the ordinance covering sexual harassment. Does that include religious organizations such as the church? I'd like the legal advisor to also help us look into that. Let's say in a religious, premises, if there should be sexual harassment in such an institution, would such acts of harassment be illegal, or would they enjoy an exemption? I understand that sexual harassment is covered by the STO. Part 3, Section 22. Section 22 of the STO refers to religious workers or clerical workers, where it said that they are entitled to exemption. But that provision said that if some religious bodies which on religious grounds would only appoint persons of a particular gender, then they will not be in breach. In other words, they say that in order not to hurt the sentiment of the congregation. Here we're talking about employees. Of course, you have fathers and sisters. Of course, a man cannot be a sister and vice versa. It's against this background that they enjoy this exemption. But if we're not talking about employment relationship, we're talking about religious institutions or churches in general. If there should be acts of sexual harassment there, then is the church or the religious organization be covered as if it were a clubhouse? In that case, the ordinance protect members of the clubhouse and so that they won't be subject to sexual harassment. So including the congregation or those who are not yet believers. Now, if these people were sexually harassed by the management or the clerical workers or the preachers there, then I think that scenario should also be covered. Could the government clarify, please, whether we are also exempting these, religious workers, so that if they are engaged in acts of sexual harassment, they would be exempted? Thank you. I think the Section 22 that you cited is about discrimination and not harassment. You also asked whether the definition of clubhouse includes the church. As to whether or not it is included, early on, another member asked the same question, and I already quoted the definition of a clubhouse. That is, it should have not more than 30 people who, for cultural, sports, social, and other purposes, who are an organization formed to achieve that purpose. You can say that the definition would also cover churches, but it doesn't explicitly say that a church is one type of such organization. Are you saying that any organization with more than 30 members would be caught? So in that case, I think I can tell you that most churches or religious organizations will have more than 30 members, unless you're talking about small religious fraternities. So in general, all the religious organizations, the members of religious organizations are protected from sexual harassment, and acts of sexual harassment are prohibited in a church, because the church is also considered to be, a club. But I think the government may need to embark on more public education, because many people think that church workers or religious workers are exempted, and think that acts of sexual harassment which take place in the church would mean that the clerical workers would be exempted, and therefore the church members would not be protected. Although the STO has been enacted before the handover, we still have many. The problem of sexual harassment is still very rampant in schools, in churches, and sports associations, and it's still a problem that we are not able to resolve. So I think the government will need to conduct more public education here, and the government should try to plug all the loopholes as far as it can. So I don't think the government has done enough. Take NSA, for example. You don't even have a mechanism for complaint against sexual harassment. And when the EOC, issue questionnaires to ask them on the subject, consult them on the subject, they didn't even bother to reply.
That's not within the scope of the amendment. Your question is whether the churches are exempted. Well, they're not exempted. As for clubhouses, the weight of 30 people committing a legitimate purpose would definitely cover churches. I know there's no precedence. And because of this, we'll examine that whether the existing scope of sexual harassment will need to be reviewed so to give a clearer idea and enhance the clarity. Currently, there will be a different interpretation. So that's why that's why we're asking for a thorough examination of the sexual harassment provisions. Next, Elizabeth Quat. Thank you, Chairperson. I'd like to follow up on the workplace participants. I hope this bill can also cover more. You said you would exclude interns and volunteers and trainees. I don't understand why they're excluded. So it seems that you're not affording protection to them. It just isn't the right thing to do. To include them, would the government think is difficult or any obstacles? We keep an open mind, but also understand we need to deal with some issues. They will be manageable, but need to deal with this strenuously. One will be the vicarious liability. We want to know, ensure that it's handled appropriately, and volunteers are quite mobile, and they could be distant from the organization. And how do you interpret definition of volunteers? The Australia have no definition. Does that mean we just want to check the common sense meaning as someone who work for free? Well, some of the volunteer we provided transportation or meal allowance. So we need to deal with this, but we will get an answer. And Chairperson, and well, there will be potential issues with covering volunteers. For example, some organization organized activities, let's say within a premise, if someone, a volunteer would serve for a long time, everyone know who they are. For a large-scale event held outdoors, and while there will be a lot of volunteers bring other volunteers, the organizer, the NGO, may not even know the volunteer. So, but how would the liability situation be like this? That's why we need to look into this kind of circumstances for vicarious liability. To look at the preventive and the remedial measures, in which there should be a policy in place that you not accept or object to all harassing behavior and encourage people to report. And for the remedial redress. When receiving complaints, you will actively follow up. But is it very difficult to take up? I don't think so. But when in actual implementation, when some organizations don't know what to do, that will require promotion. So the government just said when anything happened, you will have a handling mechanism on prevention. You no idea who the volunteers are, and don't even know it exists within this volunteer team. The organization may have such information uploaded to the website or brief the volunteer leaders that on what kind of behavior should not be tolerated. Would that be enough? Well, if the volunteers are brought by volunteers, the organizer might not be directly contact with the volunteer concerned and tell them that we have such policies in place. Well, looking on depends on the circumstances while you do your most and under available resources. I think the court will take into account of the facts. In this way, the chairperson, I hope the administration could look into it, how to come up with this better bill. Under Secretary, I will give me an answer. Next, Dr. Chen Chung-tai. So on the previous administration response to this bill on the applicability on the application for the West Kowloon Station mainland port area. So that is one of the reserved matters under the co-location bill on the applicability of matters pertaining to the contractual or other legal relationships of a civil nature. The administration claimed that the current discrimination ordinance apply to the main MPA. There's still some yet to be clarified. On the current cooperation arrangement at the MPA, on the civil or legal relationships of the civil nature, let's say they have elements involving other jurisdictions, and when Hong Kong experience discrimination relevant to the full discrimination ordinances, would it affect the Hong Kong courts to handling this kind of civil litigation? According to the PRC's People's Supreme Court ruling on the promulgation of the law applicability, if one or two parties of them involving foreign nationals or foreign corporate or be living for a long time outside of PRC, this external relations law would or civil law will apply, and the People's Supreme Court would have interpreted this law that the relevant law or the litigation, which part of it will subject to the PRC laws and courts. For this full discrimination ordinance, which are the reserved matters under the co-location ordinance, when the actual implementation where the civil litigation is confirmed, this is the first time where this ordinance is relevant. When it comes to enforcement, when our courts when deal with racial discrimination and sexual harassment where foreign nationals are involved, even though it's the Hong Kong courts will have the jurisdiction over civil matters, How could in the MPA, according to the directions of the Supreme Court, there's some elements, for example, that such a foreign relation with foreign connections will affect our jurisdiction? It took like 3 minutes. Can you answer his question, or you have to consult the DOJ? It's quite a complicated question. Let me examine it and reply you in writing. I want to carefully examine this. Well, there's special circumstance where what it may occur in the MPA for other contractual or patent protection. For these matters, well, both sides may make some actual undertaking. For discrimination ordinance is one area of human rights protection. So I want to know if the Hong Kong operator, the contractor, the material supplier, and all these units, and even the passengers, for let's say some mainland passenger at the MPA accuse a operator or service provider of breaching the discrimination ordinance, and how would the local court accept this case? So let's say the parties are not Hong Kong passengers or mainland passengers, or whereas passengers of a foreign country is involved. So the Supreme People's just so there'll be area under the civil litigation involving foreign nationals. So maybe the Undersecretary can consult the DOJ, the relevant departments, in giving the written response to us. If you'd like to find out more, you can contact Mr. Dr. Cheng direct. And so you can submit us a written report. I think what he cited is limited to discrimination ordinance. It's just the MPA with interaction with other jurisdiction. So we'll find out from other departments. Hopefully they'll have an answer. Next, Mr. Ted Hui. So let's go back to discrimination and breastfeeding. So there's no point in pushing them. Don't intend to go along. In your response, you claim that it's technically unfeasible. So it's technically infeasible. There's probably a legal concept. So does that mean it's not legally feasible in the future? Let's say if there is consensus to go ahead, and then we will check it out to examine independently. So does that mean that this being technically legally infeasible will rule it out feasible in the future? Or can you promise with a timetable that when will you undertake include provisions on harassment on breastfeeding, because it would directly affect the handling of this panel? Regardless of what, we're gonna move amendment and also seek the Bills Committee to support and ask the legal advice to draft and move amendments in the name of this Bills Committee. But whether to do it or not will depends on the administration's attitude. So can you explain what do you mean by technically unfeasible? It's not that we cannot draft it. It's that the legal framework does not allow to sneak something in. You just can't sneak it in. So just fail the scope test. So it's exceed the scope of this amendment. So it's not technically feasible within this bill. It's not that we can't draft it. We can draft it. However, we require a new bill. And for your question on our position, we accept the suggestion that we need to deal with this. There are two ways to go about it. One would be to thoroughly overhaul it together with sexual harassment, to examine in depth, working with the EOC. So that will take longer. However, they will give better clarity and easily apply, which will help to solve the problems. And another approach will be have been mentioned a few pages. So why not we using the exist designated relationships under SDO to introduce a new amendment bill to deal with this. That's why we can go back to take a look. And so I would like to seek the members' view to give a clear direction. Since we have 27 priority areas, and now we deal with 8, and the EOC suggestion list there is 19 yet to be handled. About a few of those are of greater public interest. However, this Bills Committee have cited the discrimination on breastfeeding seems to be the most urgent priority. So we will take a look at whether we can allow this amendment, this matter to jump the queue.
We are prepared to look into that, and we have an open mind. But given the scope test, so to resolve this issue, we will have to actually draft a separate bill to address members' concern. I would like to state my position. Of course, I hope you will do it as soon as possible because the problem is there. So you're not going to do it this time. So the Bills Committee will have to study into whether or not we can do it ourselves, whether or not it could be done. And if you're going to do it in future, I'm agreed that you should do so by way of an amendment bill, even if you have to jump the queue. That would be better than conducting a further study because that may take a long time. I don't think the Undersecretary, I don't think there is any necessarily a question of, jumping the queue. Now, if as a result of our discussion, we need to move an amendment, and we know that amendment may be out of scope, just like the example of the stamp duties amendment bill, because there is the need and the amendment was technically not feasible. That's why the government moved a number 2 amendment. So for the present amendment, if it is beyond scope and we cannot address that question, then if we have to wait for your alternative amendment, we may have to wait for a long time. Then we can proceed with the present amendment first, and then your second amendment can be, tabled, later. Matter procedure. I've already served notice that if the government is not willing to move that amendment, I hope the Bills Committee will do that. In the past, many Bills Committee would, where there is a consensus among members, ask our legal advisor to draft an amendment. So I'd like to ask the chair to address this question first. Well, that depends. If you really want to make that proposal that the Bills Committee should move an amendment, then it would be best for you to make that proposal so that at the next meeting we can. Sorry. Well, we still need to finish the clause-by-clause scrutiny. After we've done the clause-by-clause, then we would next, deal with the question of CSA amendments. So at that time, members can decide whether we agree to do that or not. I agree. I think that's the approach we've taken before. But if all members agree that I can ask the legal advisor to draft an amendment for our discussion, and that would take time. So I think we should we could ask the legal advisor to do that first, so that we don't have to wait. Well, the legal advisor doesn't have anything further to supplement, but he take note of your point. I heard you say that if the government were to address the question by way, if we don't do that by way of a separate amendment, then you will move one yourself. Now, for members' reference, since members have now put forward this request, then we are prepared to address that by way of a new amendment. We will seriously consider that proposal, and we can come back with an answer at the next meeting. And then members can decide then. We will first finish the clause-by-clause scrutiny before we decide on the subject of CSA. All right. The last member for the third round is Dr. Wong, Madam Chair. I'd like to ask the administration about Part 5 of the bill, which concerns the interns or the unpaid trainees. Originally, the government said they want to listen to our comments. Now that you've heard our views, what is your position that is whether or not you're going to cover the unpaid interns and volunteers? Because it's not just in Australia, in New South Wales, Australia, and the state of Victoria, where they do have such provisions to ban sexual harassment of volunteers and interns. In California, New York, and Oregon, and Colombia, in many such jurisdictions, they also offer protection to volunteers and interns from sexual harassment. If we want to make reference of the practice in other jurisdictions, I'm sure we can learn from the experience. So at this stage, I'd like to ask whether the government is prepared to consider covering volunteers and interns, so that they get protection from sexual harassment. Because if you don't, then we may need to consider drafting an amendment of our own. Well, we have an open mind. The member asked whether we would consider expanding the scope of protection to cover volunteers and interns. The answer is we will consider that. After we've considered that and we find that we cannot resolve all the issues, if we can resolve those issues, then we can move an amendment. But if we discover that certain issues that cannot be resolved, then we will also report to members accordingly. Madam Chair, I'd like to also supplement on the point regarding clubhouses. Dr. Wong asked whether it would include churches. The answer is yes. Right, so that is, members of clubhouses also enjoy protection from sexual harassment, subject to the passage of this bill, because this is one of our proposal. Right now, it's not provided for under the current ordinance. So in other words, members of clubhouses will be able to enjoy such protection when this bill became law. And clubhouses would, definition of clubhouse include churches so long as they have a congregation of more than 30. Yes. Under the RDO, there is already a similar provision, and that's why we are using the provisions in the RDO and apply them to the SDO and the DDO. What about the threshold of 30 persons? Is there any justification that the threshold should be 30 people for clubhouse before they are entitled to protection? Well, that is actually laid down, is a definition laid down when the RDO was drafted. Well, do we have any room for amendment here? What do you mean by that? That is the size of membership of the association or the clubhouse. You're talking about organizations like clubhouses or religious organizations or NGOs, whatever they may be. I don't understand why the threshold is set at 30, although you're saying that this is the number, the threshold in another ordinance. But what is the justification here? Well, I don't have information on that at the moment. Could you check and come back to us at the next meeting? Because I don't know. Because for most clubs and organizations, is it that most the membership normally would exceed 30, or is it that we have many NGOs and similar organizations with fewer than 30 members? Because it also includes NGOs. The definition of clubs or clubhouses, other than the RDO, it is also defined under the SDO, and the threshold is also 30. We certainly go back and check what is the basis for setting it at 30. I'd like to ask another question regarding the tenants of subdivided flats and protection for such tenants. Originally, the government intended to cover these tenants, but now apparently you want to leave them out. It's not included in the present bill. Yes, indeed, you're not covering them under this bill. Recommendation number 18 is that the three discrimination ordinance would protect the tenants of subdivided flats from sexual harassment, disability harassment, and so on. So what is the resistance that you've encountered so that you're not able to cover them as well this time? We want to do it in the next round. That's what it means. We're not able to do it this time because we have found that there are certain practical difficulties that we cannot resolve because there are different types of titles and in the case of subdivided flats, we found that in certain leases there is only one lease for an entire building, where you have many subdivided rooms or cubicles, and so the titles cannot be clearly defined. So that's one example. So we need to work further on this and see whether we can come up with a similar and feasible way. Otherwise, so for example, where there's a single lease, then the tenant may cover the tenants of the whole building. So the question of title is something that we would look into. Legal advisor. Regarding churches, although you may not amend the definition of clubhouse, but actually you're talking about amendment in respect of people applying to become members. Please speak into the microphone. It is not that the church is not subject to the regulation of the law, because for example, if you have a member of a congregation who want to, go to the church to worship, he's using the facilities of the church. In that process, other people cannot, engage in any sexual harassment against that person. But it's not drafted, as a religious, institution. Well, I think we have discussed different areas, and for some of our, suggestions, you said you will go back and look into that further. So could you give us written answers on subjects regarding volunteers, the church, the schools, the discrimination on the basis of breastfeeding, and so on? So tell us what exactly is the position of the government and how you propose to follow up on that. Could you please give us a written reply? And also the legal point raised by Dr. Chang. Could you consult with the relevant department and come back to us with a detailed answer? I think it's almost time. At the next meeting, after we've studied the government report, we can begin our clause by clause. The next meeting is scheduled for the 7th of May, Tuesday. I think that should allow enough time for the government to prepare the detailed report. Thank you very much. We are adjourned now.